Hey, welcome to tonight's show. Freeman and I are here tonight to talk to you about a new subject, will contests, and how they get there and what happens and what the elements are to prove it and that sort of thing. Before we talk about contesting a will that somebody's made, we first want to review with you what happens and what's required to have a valid will and what happens if you don't have a will. So, Freeman, would you take that over and let's talk about the requirements for a valid will?
I'd be glad to. First, you need to be the right age. You have to be 18 years or older. You need to have signed the will. You need to have 2 witnesses signing the will. And probably the thing that gets contested the most, you have to, what you're signing has to be what you want to actually have happen. You have to be of sound mind, which means you can't, not know what's going on, and what you're actually doing or giving away in your will has to be what you actually want to give away to your family members or whoever else. And those are actually probably the 2 things that get contested the most.
Let me ask you a couple of questions about that. Do the witnesses generally have to see the person sign the will?
Yeah, the witnesses would hopefully do more than even watch you sign it, but I think that's all that's really required is they watch you sign it, initial each page, that sort of thing. You could have them witness more than that, taking the person that's signing the will through a series of questions to make sure they're of sound mind.
What happens if somebody can't write, but they can sign an X? Can they do that?
They can. They make their mark, or they can have someone sign it for them.
At their direction?
At their direction.
Yeah. Okay. Now, you and I have had occasions where we've gone to the hospital, somebody's on their deathbed, or we've gone to a nursing home even, or whatever, and we go in there to get the person to sign the will. What procedure do we follow to try to make sure that will stands up?
Well, we'll ask them numerous questions about what's being done in the will is what they want to have done. Have they been influenced by anyone to do this, or are they doing this of their own volition? Are these their wishes? And then we'll take them through a series of questions about everyday society. What year is it? Who's the president? Can you tell me, what you did today? Stuff like that. That way, in case later on, if we actually have to testify to their capacity on that day, because that's really all that matters. Their capacity that day, it's not the day before, 2 months before, it's that day that we believed that they were of sound mind and this is what they wanted to do.
Do we allow anyone else to be in the room when we're doing this?
There's certainly no one that's going to be getting anything in the will. You want the witnesses obviously in the room, but no one that would be receiving anything in the will.
Let's take an example, and I think you had this a couple of years ago, where you had an elderly man who wanted to do a will, and there was some uncertainty, maybe a little bit, about whether he had the capacity to sign the will. What did you do in order to substantiate in your file that he had the capacity to sign the will?
Well, first, I guess I'd clarify, there wasn't any doubt in my mind that he had the capacity or I wouldn't have done it. But there was some, I guess I had an inkling that there could be a problem possibly from some of the other heirs. And in order to head that off, I had him go see a neurologist that day to be checked out, so there would actually be a medical record of him on that day that he signed the will that said he was of sound mind that day. And it wouldn't just be my word, it'd be a medical professional doing it as well. And that's an easy way to help stop a will contest in its tracks.
And you also said that you didn't want any heir or person who might ordinarily take to be in the room. Why is that?
Well, that would be, to me, that could be seen by a judge or a jury or an heir possibly looking at something as undue influence. If they're in the room, why are they there? They don't need to be there. I mean, I wouldn't necessarily have an issue with them, sitting outside, but they don't need to be in the room while we're taking them through the series of questions whether this is what they want to do, because they may be afraid to answer honestly.
Okay, now, before you got to the hospital, you already knew or believed you knew what that person wanted to do with his or her assets, because the will basically is designed for that person to be able to tell the world what he wants done with his property. And the reason to do that is so the state doesn't end up in an intestate situation where there's no will, and the state tells you what's going to happen. So before you got there, you knew what his wishes were. How did you find that out?
Well, typically you'd meet with them once to find out what the wishes are, and then you'd actually prepare the will, and then you would have them come back in, or you would take it to where they are for them to actually sign the will.
And they, of course, read the will before they sign it.
Of course.
Yeah.
And that's why you ask them again. I mean, some people change their mind pretty quickly, so you want to ask them again, not just the first time when you write everything down, but even the second time when they're going to sign it, you take them through it again and say, this is what you want to have happen.
And of course, if you do have serious doubts about the person's capacity to sign a will, he knows where he is, he knows what his objects are, he knows what he wants to do with his property, and you have some concern that he doesn't. Say he's an Alzheimer's patient or a dementia patient. Are you going to let him sign a will?
Well, if I had doubts on that day, then I would not.
Okay.
But everyone who's dealt with someone that has dementia or Alzheimer's knows, or a lot of things. We had a will contest that we actually had a jury trial on a couple years ago, where the man would go in and out of consciousness, basically. And not just being awake or asleep, but knowing who people were or what was going on that day. And all that matters is how are they right then? Mm-hmm. You know, they can be out of their mind the day before, but as long as they know what's going on that day that they're signing it, then it shouldn't be a problem.
Yeah, that's a good point. And let me, what I've got with me today is I brought some information from the court system in which the jurors are actually told this in a will contest. Let me read this to you about wills, because people get confused about this. A person of sound mind has the legal right to dispose of her property the way he or she pleases. We are not here to decide how he or she should have disposed of her property, or how you would have disposed of the property, but we're here to decide if it's his idea. We're not concerned about whether he acted fairly or generously or kindly. We're simply here, and we're here not to rewrite the will. We want to make sure it's his will. That's what they're told to do. We'll be back in a minute to talk some more about that. All right, we'll continue our discussion here about will contests by telling you this. You've reviewed with you what's required to have a valid will and how it's executed. Let's suppose that somebody dies and his will is presented for probate. By the way, you only file a will for probate after somebody dies, not before. The court won't accept it. But you got a death. A lot of people don't know that. But you got a death, you'll file a petition to admit the will for probate. And Freeman, talk a little bit about what generally has to be in that petition to try to get that will admitted to probate.
Well, you'd need the actual will, of course, and then you'd need a document. Normally in a will, there's going to be someone named as a personal representative or executor. They'd actually be the one filing to have it admitted to probate. And then you're also going to be running an ad in the paper for, I believe it's 3 weeks.
For creditors?
To notice all unknown creditors. Any known creditors, you actually have to give them notice, I believe, within 30 days. And that's
who has to be notified about the filing of the petition? Or go ahead.
Any potential, first, anyone that's listed in the will, any next of kin, it'd be a pretty good idea to do is to notify them as well. Notifying who you notify is really one of the most crucial parts of filing a will or admitting something that to probate that doesn't have a will.
And when you file that petition, you're required to disclose who all the next of kin are. And those are people who might inherit if you didn't have a will. And the reason for that is you got to give them notice that there's a will that's going to be offered for probate, so they have an opportunity to contest it if they decide to do so.
And that's why one of the first things we will do will be to reach out to the next of kin and ask them to sign waivers.
Yeah.
Once they realize they're not.
And the waivers mean, of course, that they don't have to go through a hearing to probate the will.
Right.
So once you file the petition with the court, then you set in motion a series of events that are going to occur. The ultimate goal is to get the will admitted to probate, which that means the court will issue an order recognizing that will as the last will and testament of the person who has died. So there's a period of time after the will is admitted to probate when you have to go through some procedures about inventorying the estate and notifying these next of kin and letting them have notice. And if they give waivers, you can go ahead and admit it to probate. Now, at that point, let me digress and say this. Let's suppose that Aunt Joe over here, who's one of 3 sisters and there are no children, she gets left out of the will. She's not happy. That happens a lot. She wants to contest the will. She has a choice to file a contest of the will before it's admitted to probate, but after it's filed in the probate office for probate. Or she can wait until after it's admitted to probate and file her contest in a circuit court by filing a petition. She has 6 months to do that. So you can do it before it's admitted to probate or after it's admitted to probate, but there's a 6-month time limit. And you have to do it by filing a petition. Most of us who do this sometimes will not file a contest in the probate court. We'd rather do it in the circuit court, where you can have a jury trial in either one, but the circuit judges are familiar with doing that all the time. It's not so familiar in the probate court. So we'd rather do it that way. So you file your petition. The next big question is, should you do one? And of course, you've got to find some evidence that you've got a grounds for a contest and that you have a likelihood of proving it. Because if it's a frivolous appeal or frivolous petition, you can be made to pay the court costs if you don't offer substantial evidence, credible evidence that there's grounds for a contest. Doesn't mean you have to win, but if you don't do that, then you can be forced to pay the court costs. So anyway, we get back to what are the grounds to contest a will. Now, if you would put that first slide up there, we're going to talk about those. Freeman, go over those with our audience.
Well, the first one is not duly executed, and that could mean that you didn't sign it, or that somebody signed it for you without you directing them to sign it, or it wasn't properly witnessed.
Or the witness didn't see the testator, the person making the will signed, and you were able to prove that.
And that's what I mean by properly witnessed. And number 2 is the person is not of sound mind. That would mean basically that on the day that he or she executed the will, that they didn't know what was going on. And this will...
Let's talk about that a minute, not of sound mind. What kind of evidence would you be looking for to trying to find that you could prove that person was now not of sound mind? How about lay witnesses? They can testify. Well, and what things do you hope? Well, if you're representing the person who's contesting the will, what is it you want lay witnesses to testify about?
About their state of mind that day. You know, did they witness anything that led them to believe he or she didn't know what was going on? If they have, you know, a lot of times you're dealing with somebody that is sick or elderly in that situation. They may have nurses in their home. They may have hospice. They may have some sort of in-home health care. Those records would be important.
And they could talk about their interactions with the testator as to whether he knew where he was and current events and that sort of thing, or whether he was just out of it.
And I think, you know, the one that we had the jury trial on a couple years ago, there was a lot of evidence of that particular person coming in and out and not knowing what was going on. And there were all kinds of notes from the in-home nurses that he didn't really know what was going on. But when he actually took action, there was a whole lot of evidence that when he did, he knew exactly what he was doing, and it was what he did was exactly what he intended to do.
Now, we're looking for evidence that the man did or the woman did what they wanted to do rather than what somebody else wanted them to do.
That's right.
That's the key to the whole thing. So, and you could have medical evidence from a doctor, a neurologist, like you mentioned a minute ago, that might say that he suffered from this and that, and I have my own, I do not believe he's capable of managing his affairs. You get a doctor to say that goes a long way if that's in fact the case. Or these lay witnesses who can give you their occurrences they've had with the person involved signing the will as to whether there was evidence that he knew what he was doing on any time.
And also on the flip side, you can have a doctor testify that, yes, the man will or the woman will come in and out, and some days he's going to have good days, some days he's going to have bad days, and then you can turn around and use your lay witnesses to tell a jury or a judge that that day was a good day.
Yeah, and knew what he was doing. And by the way, I'll interject here that the decision to file a will contest is based not only on whether you have credible evidence to offer, but also, is it worth it? What's at stake? In my career, I've handled 2 or 3 will contests that involved $8, $9, $10 million. And when that happens, it's usually worth it. But you get a small estate of 20 or 30,000, it may not be worth it, because you want to look and see where you would come out after the contest is over. And for example, if a man does a person or a woman does a will, it automatically revokes any prior wills. But if the will you're contesting fails and it's not admitted, it's thrown out, you go back to the last will if you can find one. If you can't find one, then it goes to an intestate situation, which means that you go by the law of Alabama as to who's to inherit. In an intestate situation, it's usually the spouse and their children that will inherit in different proportions based on how many there are and what kind of property it is.
Well, that can be a complex situation in and of itself, trying to just explain the math of that, especially if you have if there's only children and some are alive and some aren't, and then they have children. We'll take the audience through that after the break, but that in itself, really, if you can't afford to avoid that, you want to, because
it's expensive.
That's not a fun situation to go.
Well, in our third and last half, we'll continue a discussion of what the grounds are and what kind of evidence you have to offer to win or you'll lose. Be right back. Okay, we're going to continue our discussion about what you have to prove and the grounds in order to have a will set aside that somebody's offered for probate. And we were talking about the first 2, and if you put that schedule back up on the screen, we'll go into the remaining ones that we have. Okay, Freeman test. We talked about 1 and 2, not duly executed as required by law. The person who, and you're able to prove this, the person is not of sound mind the time he signed his will. And by the way, any one of these will result in the will being thrown out. You don't have to prove all of them, any one of them. The third one is the one that's most commonly used in will contests. Freeman, let's talk about undue influence.
Undue influence would mean that you have a confidential relationship with the person that's executing the will, that you could be deemed, or you will, if you're found to unduly influence, that you controlled that person, that you've had a dominant relationship with them and they basically do what you tell them to do, and that you have actual involvement in the transaction that is being disputed, which could be a deed. In this case, we're talking about wills, that you actually had involvement in that transaction taking place, and you exerted your dominance over that person and your confidential relationship with that person to make that transaction take place.
Okay, let me read you something again from the Alabama jury instructions. This is what a jury is told, and this is gives you a pretty good idea of when it is and isn't it undue influence. I'm going to read this verbatim. If the person who made the will was influenced by affection, gratitude, family or personal relationships, or ordinary advice or argument, this will not invalidate a will. This is because these things do not destroy the person's own free will. If he makes a will because of fear, desire for peace, and could not resist, and is virtually the same force of fear, this is an influence that will invalidate a will. I've seen, and I'm sure you have, older people who may be weak of mind and frail, and they don't want to argue about it. So what they will do is they will do what anybody tells them to do. That's the kind of undue influence. It's not influence, it's undue influence. And that's where they're told, Mama, you've got to do the will this way. This is the way we want it, the way I want it. And you're not going to get anybody to admit that. But you might prove circumstances that show that and give a jury the right to invalidate a will. So it's that undue influence which overpowers the free will of somebody to make that decision about what they want to do with their property that will invalidate a will. Now, you mentioned a minute ago, Freeman, about confidential relationships. What does that have to do with the will contest when we're looking at undue influence?
I don't think I understood your question, but if you want me to just talk about confidential relationships.
Yeah, I do.
that just means that you have a close relationship with them. That person confides in you. That you have the type of relationship that you could unduly influence somebody.
And it means that person to be the dominant and the controlling over the person who's made the will, that he can tell them what to do and they will do it, rather than be their own free will. That's what you're looking for. It's getting that person to be able to make or sign a will that you want rather than that person wants. Mm-hmm. Now, some of the evidence that you look at in these things would start with who brought them to the lawyer's office, who was in the room with them when they signed it, what role did they play in getting that person to sign it. You have to prove all that. Sometimes that is what is going to make or break your case. Let me give you some examples that the law talks about when you have a dominant or controlling influence, because that usually is what results in a bad will. You want to look at the age of the person who made the will. Suppose they're 95. They can barely walk and they can barely express their opinions, for example. Suppose their mental health is weak. You look at that. You want to look at, and we've done this, is the person who's made the will a strong-willed person or a weak person? And we've had evidence, as you remember in the last case you talked about, a lot of people who had no say-so in the outcome of the will, could care less, talked about what a strong-willed person this man was and how he made his own decisions. That's very important inference.
There was some pretty unbelievable testimony in that particular case about.
Can you, without saying exactly, you want to paraphrase what that was?
Well, no, not really, because but there was evidence of, and basically quoting him, which you could since he was gone, that made it quite clear to everybody of his intent and
why he gave a reason,
right, and why this was his intent.
He cut somebody out, and he gave a reason.
He didn't cut him out. He decreased what they were getting.
Almost cut him out.
No, they got a lot.
Well, they didn't get all of it, though.
No, they didn't get all of it.
Anyway, there was a dispute over the allocation of the assets. And you want to look at whether the person who's made the will has sought independent advice from somebody who has no axe to grind and nothing to gain out of this.
That could be a lawyer. Yeah,
it could be. Now, the lawyer, by the way, who does the will is usually going to end up being a witness in these cases. He's going to testify as to by the testator presented whether he thought they had a strong mind or not. So the lawyer who does these wills is not going to be able to participate in a will contest case. And you look at whether those persons had the ability to dominate and control and influence the person making the will.
I think something else, not to interrupt you, but I think something else that's important in these is that if you happen to be getting a will done that's not being done by us, to make sure that when you go into the lawyer's office, that all these questions that I talked about in the first segment about, is this what the person wants, and then stuff with their state of mind about what year it is, all of that stuff gets asked because, if a lawyer does a lot of these, they may not remember yours. So it'll be important to be able to ask that lawyer and the people who witness that will, which generally will be the same people witnessing all of the wills that take place in that lawyer's office for the most part. Have you, it'd be helpful to ask an assistant, have you ever seen such and such, one of us, go through a will with somebody and not ask them these questions? Yeah. Because that can be evidence that it happened and it can help you say, yeah, this person is of sound mind.
And we also, as a practice, make notes about what our conversations are with the person that we're trying to make sure that it has the ability to sign a will and does sign a will. So, and that's to substantiate that the will was done correctly. Now, there are a couple of other grounds. Would you put that up? Will procured by fraud or executed by mistake or been revoked. Those are pretty simple, easy issues. The undue influence is the main thing. By mistake, let's suppose that he signed the wrong will. There were two wills prepared and it was proven that he signed the wrong one rather than one that he intended. You prove that, you can throw it out.
That could also be fraud too.
Yeah, it could be fraud. Somebody got you, a 95-year-old man or woman who cannot read, cannot understand very well. You put it in front of him and you tell him what it is, and you don't tell him the truth. You've induced him to sign a will that's not his. That's one procured by fraud. How do you prove that? Sometimes that's tough. And finally, the last one up there, would you put that?
Just being revoked, and that would just essentially mean that it's revoked by another will that was that he executed later on, or part of it was, changed by codicil even later on. It could be a number of things, but the whole revoked would require him to
Okay.
execute another will.
Now, what's the result? If you win your will contest, that will goes out. You either get the one, if you can find it, the one that was done before, or you end up with no will and it passes according to intestate law. But you better make sure there's enough at stake to warrant the contest, because it's expensive to bring them.
Yeah, and then if you have, for instance, very quickly, if you had 3 kids, they're each going to get a third.
Yeah.
If one of them is passed, their children will split that third.
Okay, well, it's the end of our show today. We hope you enjoyed it and learned a little bit about will contests. They're not easy.
Thanks for tuning in.
Yeah, thank you for looking.